Sick. Today we're going to be going into non-immigrant visas and transitioning from a non-immigrant visa to a green card. Now, non-immigrant visa and immigrant visa, there's a big difference between the two, and I think there's a lot of confusion around what a non-immigrant visa is and what an immigrant visa is. Not only with the layperson, but also with a lot of immigration professionals, right? That don't understand the difference between an immigrant visa and a non-immigrant visa and what you can and cannot do on those visas. So what is a non-immigrant visa? How is the U.S. immigration law define a non-immigrant visa?
So it's something that is not permanent residence. So it's temporary in nature.
So when you're on a non-immigrant visa, your intent should be temporary in the United States. You shouldn't have the intention to stay here long-term or permanently, right? It's always subject to an extension, and ultimately your time in the U.S. will end. That's the way they look at a temporary or a non-immigrant visa. The most common ones we see that people use as far as a non-immigrant visa are a visitor visa. So Canadians come in as non-controlled Canadians or just on their passport, which the rest of the world would refer to as a B visa.
Right.
Other individuals throughout the world have to actually get a B visa foil in their passport to travel.
Right, and then those that don't have to get a B visa would have to get an ESTA.
Or an ESTA.
Yeah.
So you have ESTA, non-controlled, visa
B1,
entry,
B2,
B1,
yeah.
B2 are the common ones. Those are all non-immigrant. So anytime you present yourself for entry to the United States, either at a consulate when you're requesting a visa, or for Canadians, most commonly at a port of entry or airport, it is presumed that you are immigrating to the United States. It's an automatic presumption that you are coming here to stay permanently. And the burden is on you to prove to the government, to the CBP officer or the consular officer or the pre-flight inspection officer at the airport, that you're only coming temporarily. That's why they're going to ask, hey, what are you doing in the United States? I'm just going to Disneyland. Okay.
How long are you going to be here? Yeah.
2 weeks.
Right.
All right. Have a nice day. Enjoy Disneyland. It could go a little more in depth than that. But in most cases, when they see that you're just coming for a temporary basis and it's as a visitor and you're not doing anything you shouldn't be doing as a visitor, we call it the smile and a wave, right?
Yeah.
Have a nice day.
For Canadians, a lot of times it's a smile and a wave.
Coming to the U.S., it's a grumpy and a entry. They may not be as pleasant, but it's that simple. You present your passport and you enter. So a B visa is a non-immigrant visa. Another common one we see is an F1 as a student, also non-immigrant. You're only coming to study. At the completion of your studies, you go back to your home country. Another common one we see, and this is the most common one we see, and that's a TN. A TN is non-immigrant. You're just coming for your temporary employment in the U.S., and then you're returning to your home country, back to Canada, or in this case, when you're done in the United States. We also see J1s. J1's a temporary visa too. You're only coming for that exchange program, whether it's to teach or learn or whatever it is you're doing in the United States under that J1, and then returning to your home country. Those are the most common ones we see, as well as an E-visa is also non-immigrant. And there's some confusion out there as to whether an E-visa is a dual intent, is what they call it, which means it can be both immigrant or non-immigrant intent when you have it, or if it's a non-immigrant visa. But the E-visa is non-immigrant. To clarify any misconceptions there might be, it is non-immigrant. One of the requirements actually when you apply for an E-visa is to show that you have a domicile in Canada. You could show proof of utilities, health insurance. You have to show your actual ties to Canada with an E-visa application.
Right, proof that you have the intention to return to Canada at the end of your status.
And you have some sort of ties there. Or as a TN, they most oftentimes don't even ask for that. You just tell them and they'll believe you. But an E-visa application, you have to provide proof of that.
Right.
Of that.
Well, we used to with TNs. We used to provide a letter from the
How they don't
applicant
even really
with their intention to state their intention. Yeah, we don't really do that anymore. It's not really required. I think if the officer has questions about it and concerns, for example, you've been here for a long time on a TN, they may dig a little deeper with you and see what your ties are.
Yeah. So case by case.
Yeah.
Most of the time with the TN, they're not going to ask. But if you've said something or something comes up,
Or this is your 6th TN in a row.
I just talked to somebody this week who, how long had that individual been on a TN, and that was their concern. I can't remember. I think it was somewhere in the 20-year range.
Wow. Yeah.
They've been on a TN.
Yeah. If I'm that officer, I'm asking that question.
So that individual actually opting to file by mail, and they filed by mail the last few years because they just don't like the interaction at the border and the questions they get around that non-immigrant intent.
Yeah.
But those are non-immigrant visas. Now, there are a couple dual intent visas that we deal with, and that is a visa that carries both that non-immigrant intent, in other words, temporary, you're returning to your home country, but it also has a component that if you change your mind, or actually you don't even have to change your mind, even if you come here with the intent to stay permanently, it's allowed.
But those dual intent visas or statuses, as we refer to them when they're Canadian, they are still non-immigrant.
It's not correct.
Right?
It's not an immigrant visa. It doesn't give you the right to stay here.
It allows you to have the intention to stay, but it's still a non-immigrant visa.
Good distinction. So it's still a temporary visa that you have to keep extending, and it doesn't give you permanent status. However, it allows you to seek permanent status without jeopardizing your visa.
Right.
And that would be most commonly we deal with an L1 and an H1B.
And O1 is also another one.
And O1
yeah.
too. Yeah, it's true. O1 is also carries dual intent. So if you're on an O1, an H1B, or an L1, you can pursue a green card with little to no consequences on your current visa status. Now, does that mean you can't go from a non-immigrant visa to a green card?
No, that certainly doesn't mean that at all. It means that you can't hold the intention when you apply for the non-immigrant status to apply for permanent residence down the road, but sometimes those intentions change. Job offers, get better. Employers want to start the process. Maybe you got married and things changed, and so just because you are on a non-immigrant visa without dual intent does not mean you can't seek permanent residence in the United States.
Intent can change.
Mm-hmm.
And I think that's one of the most important things to help people understand is intent is fluid. But at the time you're getting that non-immigrant visa, at the consulate, at the border, at the airport, it must be temporary. Now, I had somebody call last week. Actually, they emailed. They had spoken to me some time ago. They had entered on a visitor visa, and their email was, "Hey, entered as a visitor. Now we got married, and I want to stay in the U.S." Well, when that person entered, their intent was a visitor, just to visit. Now they have since married a U.S. citizen, and now their intent is, you know what? I can't be apart from my spouse. I don't want to go back to Canada. How do I make this permanent? That person's intent has changed from visitor to now, you know what? I want to make this permanent. That individual has changed their intent, and they can file paperwork that would allow them to remain in the United States. They could do what's called an adjustment of status in the United States through marriage to a U.S. citizen that would allow them to change from a visitor, temporary, to permanent U.S. resident or green card. So their intent can change.
They can certainly do that, but they need to be aware that there is a presumption if they do certain things within certain timelines that they lied when they came in. So they need to be careful of that.
Yeah, if you come to the border today and you say you're a visitor, and tomorrow you put in a piece of paperwork that says you want a green card.
Or you go get married tomorrow.
Yeah.
They're going to think, they're
Quit
going to
your job
presume
tomorrow,
that you lied to the border
make permanent
officer.
actions immediately after entering the U.S.
Yeah.
that indicate permanency, whereas yesterday you said you're temporary, or even a week or a month ago, right? If it's too soon and you're making these permanent actions too soon, the government sees that as fraudulent. Hey, you're doing this too quickly. No normal person changes their intent that fast.
Or there's no way that you didn't know you were getting married tomorrow when you showed up at the border yesterday.
For a while, and you lied to us at the border or the airport or wherever it was.
Right.
So you have to be careful of that component. But if managed properly, whether you're on a TN, a B, an F1, a J, an E, if something happens after you've obtained that visa that would alter your intent, and then lead to you wanting to be here permanently, your intent can change.
Mhm.
And if done correctly and the proper paperwork filed, you can change from that non-immigrant single intent visa to a green card and permanent residency.
Yeah, we've helped lots of people with
A
that.
lot of people. Now, there are some complications when you're going through that process, where if you file for a green card and you're on a non-immigrant visa, you can't leave the country. One of these single intent visas. If you're on a TN, a B, an F, a J, an E,
Yeah.
and you file for adjustment, you are not authorized to leave the country.
Well, you can leave. Nobody's going to
You
stop you from
can.
leaving, but the hard part is going to be getting back in. So they're not going to readmit you to the country as a non-immigrant when you already showed
You can
them
refuse your
that
entry
you want to
altogether.
be an immigrant. They'll just say, "Hey, I'm sorry, you can't come in." You already expressed that you want to be here permanently, so we can't admit you to the U.S. because we know that's what you're trying to do here. So if you do that, you need to
You jeopardize.
you need to
your
bite the
ability
bullet
to
and
reach out.
stay in the United States until you either get travel authorization or your green card.
And by U.S. immigration law, if you depart the country during adjustment without authorization to travel, you abandon your
Yeah, the
application
whole
by law.
application's
And you have
abandoned.
to
So
start
all that
over
money,
again.
all that work that you put into it.
Start
Yeah.
from scratch.
Yeah.
If they let you back in. So case in point, I had a client who did this over the weekend,
What left? The United States?
left the United
Oh
States,
my gosh.
but they let him back in.
Oh, they
So I
did.
had a call this morning to discuss what happened.
Yeah.
So this individual is on a TN visa,
Okay.
married to a U.S. citizen. We filed an I-134 consular processing, okay? Because this individual said they wanted to travel. I'm like, okay, we'll just file it for
Oh, yeah,
consular
we do that all the
processing.
time. Yeah.
Well, the individual showed up at the Pearson Airport. Red flag, Pearson Airport, they can be a little bit difficult. They got pulled into secondary, coming back on
Because
their
of a pending I-130 or approved?
pending. It's
Okay.
not even approved.
Oh, okay.
But they got pulled into secondary, tried to enter on their TN. In secondary, the pre-flight inspection officer said, hey, I see you have an I-130 filed for adjustment of status. It wasn't filed for adjustment, it was filed for consular processing. But oftentimes our clients don't fully comprehend. She didn't understand, and she assumed that the border officer was correct and that she had filed for adjustment. She said, yes, I did file for
geez.
adjustment.
Whoops.
Then they put her through the ringer. Fortunately, she had her kids with her, and she's a likable person, and
Yeah.
they let her back in. They said, you better not leave the United States again,
Oh, wow.
which is very lucky.
Yeah.
But at the same time, they were wrong.
They
She
were.
didn't file for adjustment. Her
Mhm.
status wasn't in jeopardy. But
Right.
the point is at that point, she declared her intent to stay here. She said, yeah, I am adjusting status, and I am going to stay in the U.S.
Oh, wow.
So they could have completely refused her.
yeah,
and
they
told
were
her,
nice
"Nope,
to her.
you're not coming back in until that green card's approved."
Yeah.
But they were nice. They exercised
They could
discretion.
have
and
let her
let
withdrawn her TN
Yep.
and told her to stay outside the
Until that
country until
I-130 is
she gets
approved.
her immigrant visa.
Correct.
Not even until the I-130s, until she goes
the
through
immigrant
consular
visa.
processing.
Yep.
Wow.
So now she's entered the
Very
U.S.
lucky.
and she's changed her mind. She's like, I don't want to go through that again. Let's just adjust.
Okay.
So now she's going to adjust status. Now she's going to have to wait a cooling off period, but she's
Mhm.
going to file for adjustment of status and change here in the United States without dealing with that, without jeopardizing her ability to return. Now, if you're on an H-1B visa or an L-1 visa, and you have your H-1B or L-1 visa is valid and you file for adjustment, those are dual intent visas, and the O-1, like you mentioned.
Mhm.
They're all dual intent, which means if you do file, it doesn't matter, you can still travel.
Right.
Because it
And you
carries
can
dual
still
intent.
renew your status too while the application is pending. So you could update your L, update your O, or your H-1B.
Without issue.
Change employers on those statuses as well.
Yep. If you are on an F1 and you file for adjustment,
Yeah.
you're not getting a new student visa.
Well, we get this question a lot because we have a lot of clients that are on TN
Yep.
and they want to switch over to H-1B. They think that it's going to be more beneficial towards getting a green card. That's really the only benefit.
That is the benefit, right?
Yeah,
you
that's
can
it.
travel throughout it.
Yes.
Other than that, what's the difference in the process?
Nothing.
Absolutely nothing.
Timelines are the same. Everything is exactly the same.
Both done through perm.
Yeah.
Zero advantage.
Mm-hmm.
Zero. And that aggravates me so much. The confusion out there behind that.
Yeah.
That you can't
Well,
go from a TN
Well,
to a
I
green
think
card.
I think the frustration is that people are waiting to get an H-1B and they're trying the lottery and year
And they
after
could have
year
started the
they're
process
renewing their
already.
TN, they could probably, if they
Could
wait.
have already got the green card.
Exactly. So I think that's our
Yeah.
frustration with it is the misunderstanding that people have that they can't start the process until they get an H-1B. That's a total
Misconception.
total misconception. It's definitely not true.
Now it is more nuanced, and you have to be careful, but really only around that travel component. And the other component is you need to file it properly, time it properly, so that that TN remains valid while your adjustment is pending, so you don't fall out of status and you're able to work throughout the whole time period.
And there's no reason why you can't try for H-1B while you're already in the perm process.
Sure.
There's no reason why you can't. So if you really want that H-1B
Go for
and
it.
you're in the perm process, enter the lottery. There's no downside. I'm doing a H-1B. One of my clients got chosen this year, and they were on a non-immigrant status, and they're switching to H-1B even though their perm is about to be, they're going to have to wait a while till they're eligible for a visa.
The new fiscal year starts in October, so we'll see how that impacts wait times. But yeah.
Yeah, but their
people are
perm
waiting.
is almost about to be approved, and they've got to just file the petition, but now they're switching to H-1B because they want to make that process easier on themselves and their family members.
And it is easier because you can travel.
Yeah.
Some people don't care. They don't care if they have that
Right.
travel ability or not, and they're willing to sit here. And depending on the process, once you file for adjustment and that immigrant visa is available, it's typically less than a year to get your green card. So it's pretty quick once you enter that final step of the process.
Yeah.
Getting there could take a long time.
Depending on your country of birth, it could take a really long time.
Yes.
So
So if you're from India, you could be waiting over a decade. Whereas I just looked at these this morning, and I got off the phone with a client, and they're doing L1 to green card. And we can talk about that.
L1A.
L1A to green
Oh,
card.
nice.
So L1A to green card, that's dual intent,
Mhm.
right? So you can travel throughout it. But also the main advantage of an L1A is you don't have to do labor certification.
Right.
You skip labor certification. And this individual was born in Canada, which is a huge advantage. And that is what is called current. In other words, the immigrant visa that you need to get that green
For
card is
EB1.
immediately available.
Yeah.
So they could file today and request it. Now you still have to wait for government processing. It's probably going to take 6 months or more to get it.
Mhm.
But there is no wait to get that because they're born in Canada and they're of a category that's current. They can immediately request that green card through that process. Huge advantage if you're on an L1
Mhm.
because you avoid perm. And anytime you can avoid permanent labor certification, we request it. We suggest it.
Yeah, and I mean because we know the end result for a lot of people coming to the United States is they prefer to be here permanently and to get a green card. When we advise people right at the start of their process, and they're choosing between an E visa and an L visa, we go over the whole benefit of the L and that path to green card, and really take that into consideration in them making their choices on how to proceed because it is a great benefit.
Yeah, huge benefit. Now, if we're going down and we're looking at these non-immigrant visas, there are traditional pathways to a green card. Most of these have both an employment and a family component to go to a green card. So if you're on an H-1B, a TN, an L, an E, a B, an O, non-controlled Canadian. If you get married to a U.S. citizen, green card path immediately it opens up to you.
Yeah, the spouse is a great.
The best.
It's the best.
Like if you and you know that.
I know that
So
personally.
if you
yeah.
go through spouse, you direct path to a green card, no matter what your status is in the United States. Now, if you're on an E visa, because it's subject to a treaty, you do have to relinquish your rights under that treaty. So there's a special form that actually most USCIS officers don't
Yeah,
even know
I
what
was
it
going to
is.
say the first time I went to an interview and we had filed that form, the officer had no idea what it was. And he said, "What is this form you filed here?" And I said, "Oh, that's because they're on an E visa." And he goes, "How? I've never even seen this before. I have no idea what this is."
And most of them don't.
Yeah.
But you have to file it.
Yeah.
Other than that, E visa can go to a green card through marriage, just like every other visa status can. And then most of them have an employment component too, where either there's a direct path to a green card, such as the L1 to
Mhm.
EB1C green card, or perm is traditionally the path. So if you're on a TN, H1B, L1B, even if you're an E essential employee or an O, then your employer can sponsor you through the perm labor certification process.
And we shouldn't discount. We shouldn't just say spouse, because actually parents of U.S. citizens get the same exact benefit as spouses of U.S. citizens.
And minor children.
Yeah, and minor children. So if you have a child who's 21 in the U.S. and can sponsor you through family-based means, then that's a great way to move to a green card.
I had a call actually this morning. Man, this is just all lining up.
Yeah.
This podcast, isn't it? I had a call this morning. The client had some matter they wanted to discuss. I didn't know what it was until I got on the phone with them. We had done a TN for this individual. It expires in 2025. So when would that be? A couple
Next
years
year.
ago. So
We
did it back in 2022, right? And they were approved for 3 years. That individual had lost their job. Just lost it last week. I was like, what do I do? I just proceeded to talk about the grace period. Oh, you have a 60-day grace period. You can either leave the country or find a new employer, and they can file to switch you to a new TN to work for them. And he said, oh, by the way, my future spouse is sitting here who happened to be a U.S. citizen, and we are getting married this month. Does that help things?
Yeah, that changes the whole ball game.
Absolutely.
We're playing a different sport now.
Now you can get married and you can immediately file for a green card.
Yes.
So that's that individual saving grace.
Right, and then if you can sit still for a few months and not work, you could get that employment authorization and start working in any job you want.
Or a
You're not
green
even
card,
stuck to the TN professions. Yeah.
That we've seen on the
That's
message
true,
boards.
yeah.
Also, we had a client, and don't quote these time frames because we can't promise them. It's the government; they're crazy.
Yeah.
We had a marriage-based green card. In other words, a U.S. citizen filing for their foreign spouse, file for adjustment, meaning they're in the United States, saying, "Hey, give us a green card."
Mm-hmm.
We're in the U.S. Approved in 3 weeks.
That's crazy. And do you
That's like
happen
Olympic
to know,
gold medal
like,
fast.
geographically where they were located?
What Canadian?
I know,
Spouse.
but do you know what the field office was?
I do not.
Okay.
Know what field
You don't know
office.
if they were here in Buffalo?
No, it wasn't Buffalo.
Oh, it wasn't.
It wasn't.
Okay.
No.
Yeah.
I don't know what field office, but it never even got to the field office at that point, right?
I mean,
That's like
routinely
still with
check.
that's still with like
But
standard processing.
But
isn't it?
processing times are based on the field office, even
office.
that when they waive the interview.
3
it's still
weeks.
based. That's crazy. I quoted somebody last week who was, I can't remember, I think they were in some part of Florida, and it was going to be 28 months to green card.
Oh wow.
That's a long wait.
Yes, but even when you're looking at that, that's all the cases there.
Mm-hmm.
That's taking into account even complicated ones.
Yeah.
So we generally don't see cases take that long. Standard marriage case we see resolved within 12 months, but less than a month, that's insane.
I think my fastest is 3 months that
Yeah.
I've had somebody adjudicated in.
I've seen
Like from filing to green
I've
card,
seen
3
just the
months.
first step get approved in
Yeah.
about a month or two, but not both. Green card, I-130 and adjustment.
Yeah.
That's insane.
Yeah, I've had one in 3 months, but definitely not a month. That's
And I did see on LinkedIn some individuals were saying that they had similar cases approved in 3 months,
Yeah.
which was insanely fast. But 3 weeks?
Yeah.
Oh my gosh.
you beat
So-
the record.
And so in this guy's case, where he's now going to be married to a U.S. citizen,
Yeah.
it depending on processing time, he could have a green card before a new TN.
Possibly.
Who
yeah.
knows,
You
right?
don't want to promise them that though, because
No.
we have no control over that.
We never promise processing times.
No.
That's for sure. So in most of these cases, no matter what visa you're on, if it's through a U.S. citizen, immediate relative, a spouse or a parent that's a U.S. citizen, there could be an immediate path to get you a green card, even though you've entered on a non-immigrant visa.
And we've definitely moved up people's timelines before to get married.
Yes.
How many people have you talked to that are like, well, we just got engaged. We're hoping to get married next year, but I guess we could do it now.
My
So
friend- yeah,
sometimes, maybe that timeline you were looking at, we got to accelerate it a little bit in a situation like yours where the job is no longer an option.
Yeah, and if it's legitimate and you're going to get married anyway, then why not?
Yeah.
I had a friend whose kid was going to school and met the girl of his dreams, and they're like, we're going to get married next year. She's on an F1, but F1, she's done with school and done with her OPT. She's like, what do I do to stay here so we can get married next year? I'm like, get married tomorrow. Guess what they did?
Yeah.
They got married within 2 weeks. Mom wasn't happy. She's like, wait, why are we getting married so fast?
Yeah.
You know, moms wanted to have this big old wedding.
Well, you can still do that. You don't
Yeah,
have to
well,
not do that.
Her parents are in Mexico and they weren't able to anyway. So when you accelerate it because of immigration purposes, you can get that legal marriage, and this is what
Get the
you need to understand.
certificate.
Yeah,
You don't have to have the big white wedding that
later.
day. You can take all the time you need to plan that. That can happen down the road.
Yeah, and that's what they're planning on doing. They did the quick civil marriage and procedure with their immigration application, and they're going to have their big invite everybody a year later.
It's a great plan.
And that's what a lot of people do when immigration is involved. In most cases, too, there's that business or employment sponsorship component too. They get you a green card, even with a TN, and that's probably what we want to clarify the most. B visa, TN, F1, all of these have components where you can go to a green card. Just because they're a non-immigrant visa doesn't mean you can't do it. You just have to have more careful planning when you do it.
That's right.
And you can transition to a green card, no problem. We do it all the time, especially our Canadian friends. We assist Canadians that have been told countless times by their attorneys or friends or whoever it might be that that's not possible. Then they talk to us, their jaw drops. They're like, wait, I've been waiting all this time to start the green card process.
There's
and I
a
could have
lot of
already done it?
misinformation out there too. So if you Google your situation and you pull up a lot of information about how complicated and impossible it is, you're probably not reading information regarding Canadians. So just keep that in mind too.
Yeah, a lot of that surrounds individuals born in China, the Philippines, or India because their wait times are so long. Where Canada is not subject to the same excessive wait periods. Well, thank you for tuning in today to the Arrive podcast. Hopefully you were able to learn some more about non-immigrant visas and going from non-immigrant visas to green cards and what the possibilities are. If you have already, thank you for subscribing to the channel. If you haven't, please do so. Share this channel with your friends, family, those out there that you think might find it helpful. And thank you for tuning in and have a great day.